I call them the strike team.
I'm Tim Lewis. I'm a senior attorney at the Puget Law Group in Tacoma, Washington. And this is Jared, also one of the partners here. And Timmy, are you familiar with the term proffer? I have heard the term proffer, Jared. You know, as somebody who's been a prosecutor for about 20 years, it's one of those terms that you hear pretty much on a regular basis.
Right. In what circumstances the proffer may be beneficial to one of our clients?
So a proffer, if law enforcement or the government tells you they want to proffer, that means that you know something they want to know, or you have something of value. And so ordinarily when they do a proffer session, they're wanting to talk to you to see what information you have and willing to share. The mistake that a lot of people make is making a proffer or telling everything they know about something to law enforcement without having consulted an attorney and without a prosecutor being aware of what's happening. Because when that happens, the person is usually giving away everything they have of value, the information that law enforcement wants, that the client has, without getting anything in return.
Have you had some experience in either requesting proffers, executing proffers, entering into proffers?
Yeah, all of the above. So in Washington State, there's a specific evidence rule, 410, that governs proffers in the state of Washington. The federal rule is 410 as well. And essentially what that means is if you have an attorney and your attorney has done what he or she is supposed to do and they know what they're doing, you'll get an immunity agreement from the prosecutor assigned to the case that ensures that whatever you say can't be used later against you in a criminal prosecution. So when you're trying to be cooperative and helpful, you don't want it to come back and actually hurt you. But the important thing to remember is you'll never have one of those agreements if it's just you and the cops in the room. You need to have an attorney, and that attorney needs to be in communication with the prosecutor.
Right. It seems like it's awful dangerous for somebody to go into that context without the representation of an attorney. You agree?
I agree wholeheartedly. A lot of times law enforcement will tell individuals shortly after they're arrested, they're scared, they're upset, they don't know what to do, that they can talk to them and tell them everything they know, and they'll put on a good word or pass on a good word to the prosecutor at a later time. That usually has little to no effect, and it certainly has no legal effect.
In my experience, Tim, is that there's actually some danger in entering into a proffer, or at least some jeopardy to the client if they don't execute it appropriately. What's the risk if you don't do it correctly from a defendant's perspective?
Yeah, from the defendant's perspective, you're giving away the one card you have to play, right? You've got information that the government wants. You want to make sure that you're getting something in return for that information. And in order to do that, you have to have an attorney that can guide you through that process and negotiate with the prosecutor, not the police, but the prosecutor on your behalf. And the other thing that I would say is if you're ever contacted by law enforcement, they want to question you regarding an investigation that you may or may not have knowledge of, or you may be the subject of that investigation. You don't have to be rude. You don't have to be mean. Just tell law enforcement, hey, look, I would love to help you out, but I want to talk to my attorney first to make sure that I'm doing everything right.